Welcome to the latest edition of Benish Bcast. My name is Rick Hepp. I'm an attorney here at Benish Friedlander in the Employment and Labor Group. There's been a lot of speculation and a great deal of concern about the Ebola virus, given the latest infections that we've learned of in the United States, the round-the-clock news reports, and just a general fear of the unknown. Today with me is Joe Gross. He's an attorney in our Labor and Practice Group, and we're going to be talking about what employers can do to address this within their workplace. Joe, obviously employers and particularly employees have concerns about whether an employee might come in contact with someone who has been infected with Ebola. Does an employer have a duty to act on threats of Ebola?
Thank you, Rick. Yes. The Occupational and Safety Health Act, OSHA, provides that employers must provide a safe and healthful workplace for their employees. So yes, there is that obligation.
Joe, what actions should employers consider in drafting a policy, and what might that policy look like?
The policy should, because if it's Ebola and it may be a transitory thing, I think the first thing that employers should do is consider that the policy be temporary, and they should advise their employees that the policy is designed to be temporary. I think it needs to be fair to the employees who have been suspected of having Ebola. So if they request leave, I think the policy should be accommodating to the request for leave. Employers might also think about paying an employee to stay home from leave. That's been in the news lately, and I think there's maybe an expectation by employees who are being requested to self-monitor, for example, who aren't deemed to be dangerous, but at the convenience of the employer staying home, I think the employer should give consideration to paying them to stay home.
Okay. Can an employer generally monitor employees to see if they are developing symptoms of Ebola? For instance, can they walk around and take the temperatures of their employees as they walk into the workplace?
Most employers aren't medical doctors. It would be inappropriate for supervisors in a factory to go around taking temperatures of employees. At a hospital, it might be different, where they're exposed to ill people, not necessarily employees all the time. But I think it would be inappropriate for employers to do that in a general sense. In addition, the Americans with Disabilities Act provides employees with some sort of privacy to their medical terms, and we have, in just the general common law, employees, for example, need to provide releases to get their medical information to employers, and without those releases, employers should just not do that.
Okay. If an employee does notify an employer that either the person has been in contact with someone who has been infected with Ebola or is concerned about that, can the employer tell other employees in the workplace? And if so, how should that be handled?
Well, that's a simple question to answer based on what I just said. Employees have a right to privacy. So unless the employee suggests to the employer that, why don't you tell everybody that I have been exposed to Ebola, the employer just should not do that. And even if asked, they should answer the question in a way that would not disclose the identity of the individual, even if the employer thinks the entire employee population knows.
So if an employer knows that an employee has been placed on self-monitoring, can the employer require the employee to take a leave of absence for the 21 days that the monitoring will take place?
Well, there's a risk, and that risk comes from the Americans with Disabilities Act, that the employer can't take an action against an employee that isn't medically required. And self-monitoring does not mean not work. So an employer who forces an employee to stay home, who has just been told to self-monitor, is taking a big risk under the Americans with Disabilities Act, because sending the person home could be viewed as an adverse employment action, even if the employer pays the employee while the employee is at home. That said, there is an exception in the Americans with Disabilities Act, which concerns a direct threat to the employee or to others in the workplace. And if the employer believes that this person who has to self-monitor is a direct threat to the workplace, that person isn't guaranteed not to have an adverse employment action against him or her by the employer, but the employer better have medical advice before considering that a person who's self-monitoring is a direct threat. So the employer should contract with a doctor, get all the facts out on the table, have the employee participate if possible. If there's a union involved, with the employee's permission, have the union involved, so that that together with the appropriate information, a good medical decision can be made.
Now, we've been talking about different steps that employers could take. If the employee workplace is unionized, if they're represented by a union, can the employer implement these policies on their own, or do they need to talk to the union and get some agreement to put these in place?
Well, if the employer puts in a policy that would provide paid leave or unpaid leave or some other kind of benefit to employees who are represented by a union, the employer, even if it's a positive change, needs to bargain those changes with the union. And that's a good thing, because in a unionized environment, employees might go to their business rep or the union official as much as they might go to an employer human resources professional. So to make sure that the union is in step with the employer, there should be some bargaining. And there might be some back and forth. There might be some positive, relatively positive changes to what the employer originally wanted to do. And if they get an agreement, they got the union agreeing with them, and it might make it easier to implement.
So finally, Joe, if an employee is on leave for monitoring or being quarantined and is ready to return to work, what steps can the employer take to kind of allay some fears from the other employees when that happens?
Again, the Americans with Disabilities Act was enacted to prevent employee fears from affecting employer conduct. But I think a reasonable thing for an employer to do would be to, when the person goes on leave, tell them that before they can come back, they're going to have a note from their doctor saying that it's safe for them to come back to work. And I think that would allay the employer's need to make sure that it provides a safe workplace for its employees, and I think by extension that should make the employees feel better, or even if it doesn't, I think that's the way it should happen.
Okay. Well, I wanted to thank you for joining us on the latest Beatcast. Hopefully this was beneficial, and we will see you next time.